And this is being recorded. So what I will do is, just because I will use this as part of social media, I will just start by saying my name is Max Chaudhary of Chaudhary Law Office, an immigration law firm based in Toronto, Ontario, Canada. We have 3 lawyers in our firm. I'm the managing lawyer, and that's why you're seeing me here instead of the other 2 lawyers. And the purpose of today's webinar is to let people know that if they have general questions as opposed to substantive advice, this can be a forum where they can at least get some direction about the issue, because sometimes the issues related to Canadian immigration law are layered and complicated and involve other types of law, like maybe criminal or international law or family law, as an example of the complexity. And so this is an opportunity to pose some of those questions. And for that purpose, I invite you to any attendee to pose them in the chat as a way of just having some sense of order to how this may go, because sometimes people do join these webinars literally 30 minutes or 5 minutes before the ending of the scheduled time for the webinar. And so with that in mind, I'll just take a quick peek at the chat section, right? And okay, I don't see anything at the moment, but again, there is I encourage you to take advantage of the chat feature for this purpose. And that way, let me just send a little message. Let's please pose questions here in this chat. Sometimes when I have these webinars, a question is asked and answered, and sometimes there is a follow-up question. And usually I can keep up and I can recontextualize the question, even though it might have been posed in an earlier time frame within the chat that's encompassing this Google Meet webinar. So by all means, let's proceed. So one question is posed as follows. Would you say there are immigration paths to Canada for residency for individuals over the age of 60? So if I talk in the most general terms and then go more specific, then I would say someone, at least under the law, obvious pathway is being sponsored. But as you may know, you have to have a Canadian citizen or Canadian permanent resident child with appropriate income to be sponsored as a parent to Canada. And if you read immigration laws and policies more recently, you'll know that although that is a theoretical pathway, the fact is they have not invited any potential candidates as sponsored parents after the year 2020. The year 2020 was the last year in which an expression of interest could be filed by the Canadian or a Canadian permanent resident child to say, I'd like to register. And it was basically a lottery system in 2020. And then people would randomly get selected. So for the years, I believe, starting in 2022, even up to now, people have been invited, but they're only invited from that pool of candidates created in the year 2020. So that means that unless you had a Canadian child or a permanent resident child who registered you in 2020, and unless they got selected in 2022 to 2024 to actually file the sponsorship, then in reality, the parental sponsorship pathway, practically speaking, does not work. So with that pathway, practically speaking, eliminated, then what other pathways remain for somebody over the age of 60? So these are theoretical pathways. They depend on the individual circumstance of the person over the age of 60. So, for example, there is the express entry system. And if you've looked at it or studied it carefully, you know that practically speaking, past the age of 35 years, it is extremely difficult to have a pathway for permanent residency. However, if, and again, if you know the selection grid or the inventory management system, namely the points for express entry, then you would know that you could get points for arranged employment, either 50 points or 200 points. Now, 50 points is not going to be of assistance at age 60. So you have to get 200 points through having a job offer that is registered. So touching upon that briefly, a registered job offer could be one where there was an LMIA, labor market impact assessment, leading to the issuance of a closed work permit. And that employer who's employing you in an executive capacity, which is a higher NOC tier level than the typical ones, because acceptable categories range from NOC level tier 0 down to 4. It was 4 in rare cases. So you'd have to be an executive managing a company, for example. And so in that situation, that's how you could be, for example, an executive, a senior executive of a company who's employed on a closed work permit. And then the company, while you're on that closed work permit, would support your permanent residency by saying they intend to hire you on an indeterminate or long-term basis after you acquire permanent residency. And or they have a labor market impact assessment that they filed for you, and you're doing senior level managerial duties to get the 200 points. And that would be another way, which is express entry in a very narrow circumstance. Another way, theoretically, is the entrepreneur programs, where, let's say, you do have let's say, a track record of running a business successfully. And what that entails is, of course, paying taxes in the country in which your business is operating and still making a profit. I mentioned that because the compliance and tax regimes in a lot of global South countries are not that, let's politely say, robust. And that could be a clue to whether or not your business is genuinely successful. And for these entrepreneur programs, they're typically expecting a net worth of around 600,000 Canadian dollars, and they're expecting an investment of about 200,000 or $300,000. And they want the business plan to make sense. So this could make sense if you're 60 years of age or a bit over 60, if you have a business and you want to establish a similar business or even a branch of your existing business, and then work in that business for 1 year. And then you could give yourself a labor market impact assessment, which ties into the second example I gave, where you get a 200 extra points because you're the person that's running the business in the capacity of an executive level manager, and you would have the points. And so that is a pathway. I mean, that being said, the level of scrutiny for business candidates is obviously a lot higher because there's a great deal more documentation than merely a reference letter about work, which is the typical core for people under express entry coming as skilled workers. For entrepreneur categories, you have to typically have a business plan You're expected oftentimes to meet with the provincial authorities related to immigration, who administer and assess these business plans based on what they think is appropriate. So, for example, they give higher points to locating in certain areas and higher points for having a business related to something in demand, like STEM, science, technology, engineering, mathematics, or healthcare, like exporting medical equipment or something, right? Or any other high-tech kind of situation is something they ascribe more value to. So in our 60-year-old's case, the best case scenario is that they have a STEM operation outside of Canada, and they believe the Canadian market or the Canadian business environment is suitable to have a branch or something related to their existing business and create jobs. It's always about jobs. And you make this presentation to the province, usually with a business plan, setting out the amount of jobs, business projections, your business history, etc. So that's, if the province says yes, they issue a certificate, and then that certificate is the basis for a work permit. After being scrutinized by the province for perhaps 18 months, they look at your business performance, they compare it to what you've expressed in the business plan, and if it coheres, then they will issue you a certificate of nomination for permanent residency. So, and then you're presumably living in Canada with PR, operating your business for another year or two, or things of that nature, minimally. So those are the pathways for 60-year-olds, and maybe even a little bit above. So with that in mind, let's proceed to any other question. So this looks like a more specific question. So I wanted to know, the poser of the question is asking about PR pathways for personal support workers. I've just completed my PSW program from Ontario. Prior to that, I did 1 year in a course as a supply chain type of training. I've got a bachelor's level degree in Nepal, unable to find employment full-time in Ontario in any long-term care facility or hospital. So what are the requirements for PR as a PSW, and which province should I look at for easier permanent residency? So the core of this question is, what is the skill? So the course has been completed. The candidate does not appear to have PSW work experience yet, but has the training. What with aging demographics in developed countries, there's no doubt there is a demand for PSWs. I just know off the top of my head that, at least in the province of Ontario, they did have a targeted draw for PSWs. But if I remember correctly, there was only 1 or 2 draws in the past 18 months. And I believe at least one of them was for the French-speaking stream. So in a sense, Ontario is a possibility, but it seems because they don't give really advanced notice about targeted draws, you're simply in the pool of candidates, and they see what their short or medium-term labor market need is, and they compare it to the job experience of the candidates in the pool, and that's how they come up with the targeted draw. So then you're kind of surprised. I mean, if you research this, you'll find out that targeted draws are common for the healthcare jobs and for the STEM jobs. And just like I mentioned, the example of PSW in Ontario, at least twice in the past year and a half. So the short answer is, we could take it as a kind of universal truth that there are aging Canadians in every province. So you could, in an expressentry profile, specify no particular province as a priority, and you might be fortunate enough, if your points otherwise align, be selected on the basis of a targeted draw. The frustration is, as connected to what I've said before, is that you get ambushed in a good way when you're selected under the targeted draw, but they don't tell you in advance. For example, in August 2024, we're going to be targeting healthcare workers. So you're just left at the mercy of the pool of candidates waiting for this kind of particular draw. So if I look at any other relevant comments to this, the presumption is when you have an express entry profile, you have at least 1 year of work experience that's skilled either outside of Canada or inside of Canada. And if I make a presumption the person did supply chain management at school and had a bachelor's from their home country, there could be they could still be selected based on their foreign work experience, but obviously their language. If again, you look at the draws, I think the latest draw was 600 something points, which is extraordinarily high. It's excruciatingly high in terms of what is really the profile of most people who have come and studied in Canada. So the only other option I could see for a PSW is if they do get a job offer under the caregiving pathways. Those pathways are typically subject to caps. There's caring for elderly and caring for children. I believe the caring for children one filled up literally the first business day in 2024. And I think the caring for elderly filled up maybe in May 2024. The background to that is that you need to have a job offer for this. And then the employer issues you the job offer, and that is a direct pathway for permanent residency, which is why, given the fact that it is a somewhat guaranteed pathway for PR, that the cap gets filled quickly. So the general guidance I would give is be aware of that category. And that kind of category means try to keep in touch with potential employers. So look on the Canadian Job Bank, jobbank.gc.ca, to see if there is a caregiving job. You may find that there may be one in a smaller province, in a smaller city, within a smaller province, which would be a sign that they may want to take you or go through the difficulty of hiring a foreign national through this program, because a lot of Canadians don't want to do this job, oftentimes, right? Anecdotally speaking, I do see, physicians from Eastern Europe who did get their PR some other way, and they do this job. But the more entrepreneurial ones, they have their own company, and then they farm out the PSW jobs to other people because there's a pool of people here. So in other words, another possibility is that there may be an agency that you could use. But I want to caution you that this is not the same thing as those programs with the caps relating to caring for children and caring for parents. That it's not the same. It's not the same thing. You would not be eligible for those capped programs because those capped programs require you to be working for a single employer. So that means it goes back to the earlier suggestion, which is try to find an employer. And hopefully, when the cap is lifted for the next calendar year, they can assist you in applying for direct permanent residence on the assumption that you will be working there for the requisite year or so, and then you can apply for PR. So that would be the best case scenario. So I think I've exhausted all of the possible pathways related to PSWs. With that in mind, there's an additional question. I'll just take a look at that. And then it says, do you need to apply to each province individually for evaluation, or is one application sent to all provinces for review at the same time? I'm going to assume this relates to entrepreneur category. If not, just text me a bit more detail. But if I take that as the premise behind the question, then yes, every province you have to apply individually. Keep in mind, the Ontario Entrepreneur Program closed without notice, I believe, 3 months ago. So it's being revamped, I think, because of a lack of popularity. But the other provinces, even the territories like Yukon, they have their own program still. So because it is a significant amount of effort, it's quite a production to even register your business intentions because, as I said earlier, you need a business plan, a language test, not a high level of English or French, but you still need a language test. They have oftentimes, the provinces have, for their entrepreneur cases, their own internal point system. And so it's like a sort of entrepreneur expressentry just for that province. So it's a huge amount of effort, I suppose, depending on the business, if it's transferable to, like, if it's not like a business where you're building ships, where you obviously have to be on one of the coasts. Like if it's a business that could be anywhere, you could have a similarly configured profile and similar business plan for each province, but you'd have to go through the effort for that. So I think that sort of disposes of most of the answer to that question. And we still have time. So if there's any other question, please feel free to pose it in the chat. In the meantime, while you're here, I'll just tell you the nature of the policy aspects for immigration, which is that, as you know, if you look at the immigration website, they have policies directed primarily at immigration officers as in terms of how to carry out their duties. And as a courtesy, they give it out to the public, to stakeholders like immigration lawyers, to allow lawyers to understand what the parameters of the discretion of an officer is. And sometimes they use idiosyncratic codes and numbers like C11 for entrepreneurs and things of that nature. So sometimes they're a little bit incomprehensible, which is why there's immigration lawyers in Canada dealing with more complicated cases, despite the fact that the popular programs such as expressentry are designed, or at least intended, by the immigration department to be self-filing. And as far as we know, a lot of people self-file. I mean, our office, we represent people who want to, out of an abundance of caution, file their case initially with a lawyer because, for example, expressentry is age sensitive. So if you file it yourself and it's refused, you may significantly lose your chance of success depending on your age if you resubmit the application. So that's one example where you want a lawyer, or if there's some other complicated issue like a previous refusal, which we do come across from clients who've self-filed, then you'd want a lawyer to resubmit that, or a licensed immigration consultant of good reputation, because we have those in Canada as well. So the question is sort of a nuts and bolts question. How much do you charge to do the express entry? So from a marketing point of view, I'll give you the floor fee. That's the approximate fee, because lawyers always couch terms and things with qualifiers. So if it's a single person, the profile stage is $1,000. And then if that single person gets the invitation to apply, leading to the requirement to file the APR, or the electronic application for permanent residence, then it's another $3,500 plus government fees. And in some cases, HST is applicable if they have lived in Canada for more than 6 months. So that's the approximate cost in 80% of cases where the person is single. So something to keep in mind, right? So that was a very simplistic question. So feel free to pose any other questions. And the other element which I commonly see is, when I think it's getting reduced now, is the this aspect of rumors that come up on online chat forums related to um, maybe a somewhat vague announcement by Canada's immigration minister. The announcement I'm thinking about is what came out in December, and again, maybe repeated in a vague way in May, talking about some other program for people who are already inside of Canada, which is something outside of expressentry, to address the amount of people who are in Canada with temporary status and who are not getting the viable pathway that they were expecting with expressentry, because points since July or so of 2022, where the points started creeping up past 460 starting in July 2022. And so it was, if you, again, if you're somebody who really follows this, such as somebody who is a temporary resident, you'll know that the points are, practically speaking, almost impossible at this point to obtain permanent residency. So in effect, the economic and political agenda or interests of Canada were a higher priority than the potential future pathway of all of those people who have temporary residence in Canada. But we can't control the uh, policy agenda for the Immigration Department, which is tied to the economic benefits to Canada, and to a lesser extent, the mandate for family reunification, which is also embedded in the law. But obviously, that only covers a small minority, well, maybe a significant minority of candidates who come to Canada. So with that being said, I'll take another look at the questions. Okay, so, okay, one question is, what if you are a US citizen, but have a criminal conviction related to family issues? Does that lead to an immediate rejection from the Canadian immigration authorities? And let me just deal with that, because I think the other question might be something different. So if it's a criminal conviction in the United States, we do what is called an assessment of equivalency. So sometimes there are these idiosyncratic laws in the United States, in some of the states, where, like, possessing drug paraphernalia is a crime, but in Canada it's not, and then there's no admissibility issue to Canada. On the other hand, I mean, that was sort of a not a common situation. The other hand, if there's like domestic abuse or things of that nature, that's a family issue. Forcible confinement, I guess that could be a family issue too. Those are in Canada, I think the latter is indictable, is serious. The first one is assault, depending on the type of assault. That could be serious criminality. And in that case, that could be an issue for admissibility. And unless 5 years have elapsed since the completion of any sentence for that serious crime, then you'd be inadmissible. That's not the end of the analysis. You could still ask for a temporary resident permit if, for example, you're being sponsored as a spouse to live in Canada. And that's one discretionary way to allow you entry despite the inadmissibility. The more common thing is DUIs. We see that, but that's also a very serious crime in Canada since December 2018. And the same guidance applies. You have to either wait 5 years, or if it's 5 years have not yet elapsed, then you need a TRP, temporary resident permit, to enter Canada. So I hope that disposes of that. I'll just go back a little bit. I'll just do this in the order I see it. This, I think, relates to the express entry fee. So how much fees does a case cost from A to Z, or A to Z, if you're from the States? And what is the typical duration from start to finish? So we, in the immigration lawyer field, at least in Canada, for processing cases, in other words, applications for visas, 80 or 90% of the time, these are block fees. So with our expertise, we give you the block fee, and 80 or 90% of the time, that's the only fee. However, sometimes the client does not tell us everything. Let's say, for example, before they hired us for their express entry, they filed for their study permit to come to Canada for the first time, and they did not declare all of their work experience. So that makes the case extremely complicated, because when you do get around to the permanent resident express entry stage, you have to file your personal history. That's everything you've been doing since the age of 18. So that's a potential misrep issue that could lead to what's called a PFL, aka, or also known as procedural fairness letter. We would charge you an additional fee for that. So again, that's sort of the 20% where the client doesn't tell us something when we're being hired, and then we discover it maybe as we're going through with things such as their personal history since the age of 18, in which case we're saying, no, this is going to be an issue. We can fix this probably, but we need more money to do the most current research related to disclosure and material misrepresentation, for example. So that's sort of the context or the caveat to the sort of block fees, which are meant to be transparent and give you and us, our side as the lawyers, an expectation, but how much time and money is involved. So with that being said, let's look at an additional question. So something about Ontario. Let's see, I'm not sure if you spoke on the OINP, but is this a good route for PR if a post-graduation work permit is being held, I presume, right? And it's expiring, and then the only way to stay in Canada, I'm filling in the gaps here, the only way to stay in Canada is on a visitor visa after your PGWP expires. And is there any other route to recommend? So this is a symptom of the changing government policies, where people had the 3-year work permit. In some cases, due to policies related to COVID, they were able to extend it an additional 18 months because nobody was working from 2020 to mid 2022. So people have made Canada their home. They've studied here. They may have, in many cases, I've seen candidates who came after high school. They worked here, got stuck during COVID here. They did work here, and now the points are not aligning at all with their expectation. And their friends who may have come 4 years earlier came with less work experience, maybe a less higher level of education, and got the PR without a problem. For example, in February 2021, there was a 75-point threshold. So they were just giving away PR during the month of February 2021 at peak pandemic time. So now we have people asking this question, which I see a lot. How do I make my PR happen, given the declining amount of time left on my 3-year or 4.5-year PGWP? Is a PNP nomination pathway better in one province or other? In this respect, all I can say is that if, and I believe, there's some variation, I'm going by memory, but I think Alberta, you could get a job if you work for 6 months in Alberta. Sometimes there's a pathway for PR, but you need the support of the employer. And that's going to be oftentimes the only answer to this. And if you cannot get an employer, and if the job experience you've accumulated during your PGWP was not in STEM, was not in healthcare, then you have to not take much trust or stock in this phantom potential program, which is meant to assuage people like you in this concern that where's my PR? My friends got it earlier. So then the other possibility is, I know this is hard, especially if you've lived and worked here for perhaps 5 years. You could leave, and if you're under the age of 28, you could work for 1 or 2 years outside of Canada, and you could be more competitive, because they do count points for work experience outside of Canada, and your peak amount of age, I believe, was 29 under expressentry. So that's not a very good answer, but that's just the way the law is. So I see somebody raised a hand, so we can do that. So maybe the person can, I think, either pose a question in the chat or any other method, right? If not, let me see if there's any other question related to this, right? Okay, so looks like there's been, just got to catch up on the text here that I see. Okay, so we see a question from, oh yes, the amendment to Canadian citizenship, Bill C-71. So I don't have good news. Our advocacy arm, which is the Canadian Bar Association, we've identified numerous things that will not work with the proposed law. So this law is in the stage of second reading, so it's not the law yet. So there are concerns about how to balance the rights of the Canadian parent and their offspring, but at the same time protect the integrity of the citizenship system. So the way they've proposed the law now is that it would be too much hardship for the Canadian parent who is trying to pass on their citizenship. They're talking about residency requirements similar to the ordinary pathway for citizenship by naturalization. So that's not going to work. So they're going to go, we're going to have, as members of the Canadian Bar Association, we'll make written representations talking about the shortcomings in this law, and hopefully they will agree to what we're saying, that it's unworkable, that it's unfair. And then they will come back and recreate the amendments to the citizenship law and reconfigure Bill C-71. So that's all I could say, unfortunately. That being said, what do I see next here? So if I read the next one, it's if you have family in Canada, like an aunt or uncle, grandfather, granddad, cousins, is there any way you could use this to gain permanent residency, like sponsorship? So let's start with the basic element of sponsorship. The obvious ones are parents, spouse, children under 22, or children you've adopted under the age of 22. In theory, you could adopt, or I don't want to use the word adopt because it's a loaded legal term. In theory, you could sponsor any relative as long as you are the only you're the only person in Canada with status, and then you could sponsor that one person who's outside of Canada. Doesn't matter what the relation is. It could be cousin or brother. It's not a common situation. I did have a case where a sole citizen of Canada did sponsor his brother, his wife, and his brother's children under what's called the last remaining family member. It's really misphrased because when you hear the phrase last remaining family member, the word remaining implies that this is talking about people outside being alone. But actually, in the legal business, we call it the lonely Canadian because there's only one relative in Canada. So that's one genuine pathway for legitimate sponsorship. The only other way is very tragic situations where you have a nephew or niece and the parents have passed away and you have death certificates, and you could sponsor your nephew or niece if they're under the age of 22. And also similarly, you could adopt a child as long as the adoption is in accordance with the laws of the country in which the adoption took place. But that's really, we're getting very specific categories which don't have broad applicability. So the only, again, now I'm sort of talking about broadening the situation, is if If you're familiar with the humanitarian compassionate category, and that relates to people who typically are established in Canada, they may not have status, or they usually don't have status. And they're seeking a discretionary pathway for permanent residency. In some cases, it's not a determinative factor, but it's a contributing positive factor that having relatives in Canada, as opposed to having fewer or no relatives in the home country, could be at an advantage. But it's only one component. The humanitarian compassion application is extremely complicated, and it's something which you'd want to get a real formal consultation, because we take a look at your individual circumstances of you and your family, and then make a judgment about whether that's appropriate or not. So that's, I hope, I disposed of that question reasonably comprehensive way, right? And then I see PSW question. I'm currently working as a PSW for the last 3 months as permanent part-time at 2 long-term cares. Do I need any full-time job, or am I eligible to file for PR from 2 part-time jobs after completing 1 year in Ontario? So the short answer is you do see, like I did mention, there was a targeted draw for PSWs in Ontario. So they would look at the aggregate of 1 year of work experience in Canada. So that could be at 2 different venues. So that could be at 2 different homes for the elderly, for example, or 2 different clients that you're doing PSW work for. The challenge, though, is what I mentioned earlier. I don't know if you were here at the beginning when I mentioned this, but you're at the mercy of the targeted draws, and you have no idea if you will be targeted in a positive way with the PSW job. So the short answer is yes, but you need some luck. And then I see a question here. Can you apply for humanitarian and compassionate grounds to bring your parents to Canada? I'm a Canadian citizen currently out of this country, helping my mother, and needing to return home to Canada this year. I need to bring her with me. As I'm not currently in Canada, I don't qualify for any other avenues. So for a humanitarian compassionate case, and this I can maybe delve a little bit more deeply into these H and C cases. So in a situation where it's the mother who is the candidate, one core element is that a humanitarian case is not subject to the requirement of any sponsor existing, nor any sponsor existing with money to promise that the parent doesn't go on social assistance. So one component, excuse me, to address is how will she be taken care of? I mean, way back when I did have a client who did an H&C case. The mother was the candidate for the humanitarian compassionate case, but she had a pension from the United Kingdom, British pounds. So there was no concern about economic establishment. I mean, to be fair, they're not supposed to assess economic establishment of a 60-year-old or 65-year-old in the same way they do for somebody who's 35. But there is some expectation that at the minimum, you're going to present a case where there's no concern they will go on social assistance, which implies that you need a close family member to be in Canada to say that I will provide support. The parent will live with me. I'm economically established at a job in Canada. And so that can address the establishment issue for the more elderly applicant. The other aspect of an H&C is hardship. So with hardship, they used to use the phrase unusual, undeserved, and disproportionate hardship. But that's not the only sort of criteria for hardship. A lot more has to be assessed, such as the conditions where the mother's passport is, her country of ordinary residence specifically. Is there some element of lack of relatives there, difficulties with crime, gender issues? Some global South countries, it's a lot more difficult to live as female without much support. Are those issues? Is is the health of the person maybe not serious, but they still need some support? Those are other elements for an H&C application. So those are something to think about. If you think that you fit that profile, then you would want to do a consultation so we can give some confidence either way that yes, there's a firm foundation for an H&C, or it's highly discretionary and I wouldn't suggest it. Either or. We can usually triangulate by getting more context and background that way. So if I see any other question here, so the other question is more related to, is H&C general? Is that a general pathway to pursue? So as I've intimated a little bit in my previous response and earlier responses, it's a very discretionary application. So by definition, the law is couched in ambiguity, because it's not like expressentry where it's IELTS number 9 equals this amount of points and age number 29 equals this amount of points, and 3 years of work experience, etc., leads to a certain amount of points. This is, we have ambiguous criteria, and the definition that we try to use is from a case, I forget the name of the case, but it's from 1970. And it's basically what would move a reasonable person to want to give some relief to the person seeking permanent residency. So again, even that phrase, that's as specific as we see in the law about H&C applications. So on the other hand, if I think of the other sort of de facto criteria, it's basically your case has to stand out. So your case will not stand out. I mean, it's sad, but your case will not stand out if you studied for 2 years, got a 3-year work permit, got an additional 1.5 years work permit, and just don't meet the points. However, if you did study here and then graduated and then worked, and let's say you have a child and that child cannot get decent medical treatment for their condition in their home country, and you can still present yourself that you can still support yourself and your family, that's a more specific wrinkle which would militate a higher chance of success for an H&C application. So that's sort of just to give you like a vivid example of the caution, because we don't, as reputable lawyers, we don't want to suggest H&C as a catch-all willy-nilly that's going to work and all that sort of stuff. It's obviously it wrecks everybody's, it raises unreasonable expectations on a client, and makes lawyers look bad if we're recommending something which doesn't have a firm basis, essentially. So those are sort of some guidance for the applicability of H&C applications. So when we see the next question here, okay, so this one is, which provinces are in most need for new businesses or workers? So the if you've read the newspapers in Canada, you might come across the phrase how the Maritimes, it's a bit pejorative, but the Maritimes is something of the basket case of Canada in terms of the economy, because too many old people, young people there are leaving, going to Ontario or Alberta. And in those cases, they really desperately want people. I had a client, Asian client, I forget, Chinese or Taiwanese. They got PR by running a restaurant, a sushi restaurant in Newfoundland. Makes good money. It's great. They close the restaurant in the winter for 3 months. They go back to China, but they got the status because they found a viable business and it serves the community. So it's one example, right? The other sort of general answer is all the provinces in the smaller populated cities, because with numerous factors such as housing, they want to spread out the growth of the population into smaller cities. But to make the smaller cities popular, they have to have jobs, which means they want entrepreneurs to create jobs, any jobs, service jobs, things of that nature. So if you have a viable business plan, the business plan would specify that, Red Deer, Alberta is missing diesel truck repair people. I want to establish a diesel truck repair facility in Red Deer. Things of that nature. So with some business research, you will find something, but obviously make sure that your business history looks like it can be transferable to the proposed business. That way, the province will favor your plan and invite you to work on that business and hopefully issue a certificate of nomination after 18 months. So let's see. I want to see if I missed anything here. Okay, so if you apply for an agency for a refugee and was denied, does that prevent you from applying for express entry after? Okay, this is an important question. So if you applied for H&C, that's a bit of an ambiguous case, because not all H&C candidates, well, many, but again, because lawyers couch things with qualifiers, many H&C candidates don't have status. So let's go on the premise that the H&C candidate does not have status. If they don't have status, they might have an exclusion order. An exclusion order happens if the immigration department or the CBSA determines that you overstayed. If you have an exclusion order, that means you have a 1-year ban from Canada, but you haven't left. So in that particular case, if you want to do express entry, you could try to file it, but then if you get invited to apply, you have to do what I would characterize as a mini agency in the electronic application for permanent residence to ask the officer to exclude or to forgive your exclusion order. I believe they have discretion for that. I haven't tried that, but H&C grounds are almost good for almost every sort of negative circumstance under the act. Obviously not serious things like being a member of a gang or being a member of a government that's committed human rights violations. H&C can't deal with that, but more minor immigration offenses, you could try that. Now, the question also said, what if you're a refugee that was denied? Can you do express entry? Refugees know or should know that when they started the process, before there was a decision, they were issued a conditional deportation order. And the condition is that they will erase the deportation order if you're granted refugee status, or it comes into force if your refugee case is denied. So let's go on the premise that this is a failed refugee claimant, and so that means they have a deportation order. So the advice would be the same. You could try an express entry profile and then make written representations saying, please use your discretion to overlook the agency, and in the alternative, please ask for maybe a temporary resident permit for this. And in the case of somebody who is outside of Canada as a failed refugee claimant, you'd have to ask for what's called an authorization to return to Canada, or ARC. Everybody who has a deportation order that's been actioned, namely where they've actually been deported, and they want to come back to Canada for any reason, they need an ARC, authorization to return to Canada. So I hope that gives the enough details to that particular answer. We're coming up to maybe a few minutes left, but let me see. Okay, to whoever, yes, you're welcome, sir, and you're welcome, miss. So we do have 3 minutes, and for the sake of completeness, I don't want to be accused of false advertising, this webinar goes on until 7 or so. So in the absence of any questions, just always the general idea is if you're going to look up something on immigration, you might come across something on a web chat like Reddit or these online forums. Just check the IRCC website too, obviously, and use the key phrase that they're using to see if anything is coming up for this. Otherwise, you may think that there's a program that would benefit you and there is no such program, or there may be a program, but the parameters are so narrow that it doesn't apply to you. So just something to keep in mind in this age of, like a gigantic, fire hose of information. It's hard to sift through it. So we try. I mean, lawyers, most reputable lawyers, I mean, they have blogs, but we have a blog too. So we try to keep abreast of the latest developments that we think are useful for candidates. So you can check out lawyers' blogs as well. So I'm down to about a couple of minutes. I don't see any other questions. So it might be that I can take a quick look. Nothing else. So looks like I'll give you back an extra minute of your time. So thank you for joining. And these are held usually on the third Thursday of every month. So if you have an issue with that, you can let us know. And our website is www.chaudharylaw.com. And the intake email is clerk@chaudharylaw.com. My name is Max Chaudhary, and I want to enjoy the rest of your evening. And have a good evening.